Sir, we good to go.
Yes.
Yes, yes.
Yes. Can you hear me?
Yes. Yes, ma'am.
Yeah. Okay, okay.
MC
Shall we
sir,
start?
इधर है?
Shall we start? But
One minute.
Yes, yes, you can start.
okay.
Madam, please go ahead.
Yeah. Good evening, one and all. This is our first ever webinar after our Haveri OBG Society officially registered, and we will hope some more, many more, with your support. It's my honor and privilege to introduce Dr. MC Patel, sir. He is a consultant obstetrician and gynecologist, Vice President FOGSI 2018, Organizing Secretary AICOG 2017, and a Chairperson Ethics and Medical Legal Committee of FOGSI 2011 and 13, and Honorary Secretary State Organization of OBG Society Gujarat 2022 to 24, and he was a Chairperson for MM 2018, Honorary Member of National Inspection and Monitoring Committee PCPDT Act Government of India 2015, Honorary Member of State Supervisory Board PNDT Committee Gujarat State 2005 to 2009. He was a President Ahmedabad OBG Society 2010 to 2011, Honorary Member of National Managing Body Indian Red Cross Society, which is a headquarters 2019 to 2022, and was a President of National Medicos Organization 2016 to 2018, and a President IMA Ahmedabad branch 2007 to 2008. He was a honorary surgeon of Indian Red Cross Eye Bank, collected more than 1,000 eye pairs, organizing chairperson for Vivekananda Namo 2013, and a president of Lions Club of Gatrodia, Ahmedabad 1997 and 1998.
Will do, madam.
Yeah. Yeah. Yes, sir. More than this, he's very dedicated to his profession, our profession, and very reachable, down to earth, and is a very good orator, and he's got a very good listener. You can call him round the clock any time, any day. He's available. He helps you in medical legal problems and any other professional. Welcome you, sir. It's honor of Haveri OBG Society. Namaskar, sir.
Thank you. So should I start? Should I start?
Yes, sir.
Yes, sir.
Okay, let me share my screen.
Yes, sir.
So greetings from Statue of Unity, tallest statue of world, and we all are proud of that statue. Warm welcome all the delegates and wishing you a litigation-free practice. At the outset, I would like to thank Haveri OBGYN Society and Dr. Surekha Handal Madam in particular for inviting me to share my views about the subject, prevention and remedies for litigation under PCPDT Act. So as far as this PCPDT Act is concerned, still sword is hanging. And we do not want to go into detail, but how this PCPDT Act came into action or came into force. In census of 1971, 81 and 91, it was found that sex ratio of 0 to 6 years of children, male to female, was deteriorating at serious concern. And so this act was enacted in 1994. In spite of this act enacted in 1994, in census of 2001, again the sex ratio was still was deteriorating. So there was a public interest litigation in 2003, and there were amendment in this act, and preconceptional sex selection was also added, and then after it is known as a PCPDT Act. PNDT Act regulation and misuse of technology was the aim of this particular act. So usually I start any of my talk with this question: is it worth discussing? Yes. And if it is yes, then why? Medico-legal litigations are increasing in number constantly and steadily, and we gynecologists rank first, not for PCPDT Act only, but in toto, any medico-legal problem, we are in driving seat. And as far as this PCPDT Act is concerned, every offense under this act shall be cognizable. Cognizable means any investigating officer may take cognizance of offense and start investigation without permission of court. Non-bailable. So bail cannot be achieved at investigating officer level. That is, if it is a police case, then police cannot give you a bail and you have to go to honorable court to avail bail. So it is non-bailable and it is non-compoundable. Non-compoundable means case cannot be withdrawn in between. Once case is filed, criminal case is filed against any gynecologist or sonologist, then result has to come. Result could be in favor, result could be against, but it is non-compoundable. So case cannot be withdrawn in between. And ignorance of law is no excuse, because as soon as any act, any law, any ordinance passes in government gazette, it is presumed by law that each and every citizen of India knows that law. So ignorance of law can never be an excuse. And see, this is tiger, they are enjoying in forest, and same way few of our friends are enjoying their practice in obstetric and any other area, and they never bother about any complication. But see, this is complication. So this type of complication may occur at any time, and there is this provision of stringent punishment in this PCPDT Act. Imprisonment up to 3 years and fine up to rupees 10,000 for person giving the aids, person who is giving this facility of sex determination or preconceptional sex selection. This is the provision. And any subsequent conviction, if the same conviction occurs again, then imprisonment up to 5 years and fine of rupees 50,000. And this is very important thing. If contravention of any provision or any rules for which no penalty has been elsewhere provided in this act, imprisonment up to 3 months or fine of rupees 1,000 or both. So this is a little serious matter, but again, very serious matter is this: name of registered medical practitioner shall be reported by appropriate authority to State Medical Council for necessary action, including suspension of registration if charges are framed. So merely on framing of the charge against any person, appropriate authority shall write to respective medical council of the state to take necessary action, including suspension. And if medical council registration is suspended, then you are no longer a doctor after suspension and you cannot practice. So this is serious provision in this particular act. And if it is convicted, then removal of his name from register of council, medical council, first offense for 5 years, and if it is subsequent offense, then permanently. So considering this serious provision of punishment, we should be very vigilant. And common reason for which sonography machines were sealed or registration were suspended or cancelled in past at various places. Let us see. Usually wrong interpretation on part of appropriate authority is one of the problem. And these were the found deficiency or inaccuracy in record, that is in form F or in register, and case were filed. Name of center not written, registration number is wrong or written wrongly, detailed address and telephone number of patient is not written, number of children with sex of each child not written or not written in detail, indication for prenatal diagnosis are not written or not written properly, result of sonography not written or not written properly, date not written, declaration of pregnant patient is not signed, declaration is not signed by person who has done sonography, antenatal sonography registered not prepared or not maintained properly, delivery register not maintained properly, doctor didn't wear apron with nameplate, board is not displayed at conspicuous place, certificate of registration is not displayed at conspicuous place. So these are some common allegation on part of appropriate authority to file a case against a doctor. Copy of Bare Act, that is copy of PCPDT Act, was not available in the hospital, and if available, then it was not a recent one, it was old one. So these are some allegations on part of appropriate authority. So naturally, prevention is always better than cure. So let us see how we can prevent it. So what to do not to end up into any case of PCPDT Act? No obstetric practice. If you are not doing any obstetric practice, then you are out of permit of this PCPDT Act. No sonography practice. But even if you are not doing sonography, but you are doing genetic counseling center, and if your center is genetic counseling center, then also you are in ambit of PCPDT Act. No pre-conceptional sex selection. This is a very important thing. If you are not indulging any kind of preconceptional sex selection, then it could be avoided. No prenatal sex determination. So it is also one more area, but very important part is comply with the provisions of Act. Because in spite of you are not doing any sex determination or preconceptional sex selection, then also merely in deficiency of record or inaccuracy of record, you may invite litigation. So these are some issues we have to take into consideration. Registration of center. No center can function without registration. So your center should be registered if you want to do practice under PCPDT Act's provision. So say for example, your center, either it should be genetic counseling center or genetic laboratory or genetic clinic or sonography center. But in any category, your center should be registered. And one more very important thing, at the time of applying for the registration, specify facility you apply for. Many of our friends apply for only sonography, and many of our friends have interest to go for invasive procedure like amniocentesis, chordocentesis, chorion villus sampling. So at the time of applying for registration, we have to specify, and accordingly appropriate authority give you a certificate of registration, and in that registration it is marked that which facility you are allowed to conduct in your registered center. So it is very important. Say for example, if you are registered for sonography only, and now you are interested to go for invasive procedure also, then also you can apply to the appropriate authority in Form A with request, and appropriate authority may consider your request. Registration of center, just I mentioned ultrasound, chorion biopsy, amniocentesis, chordocentesis, fetoscopy, fetal biopsy. So in Form A, you have to apply, and it is to be applied in duplicate. If your center is registered, then you are given a certificate of registration, and it will be given in Form B, and validity of registration is for 5 years from date of issue. Renewal of registration. When your registration is expired at 5 years, then you will have to go for renewal of the registration, and you will have to apply for renewal of registration in Form A again in duplicate 30 days prior. So you will have to apply 30 days prior of your expiry date of your certificate. And again, if your case is eligible, then you will be given renewal of the certificate of registration for 5 years. And at this time, fees which is payable will be 1.5. If you are going for fresh registration, then full fees you have to go for 25,000 for single unit. And if you are multi-speciality in the sense, you are going to go for all the procedure, etc., and it is corporate hospital, then 35,000 is the fee. But at the time of renewal, you will have to go for half the fee. There is one more provision. It is provision of deemed renewal. If there is no communication on part of appropriate authority, once you have applied for renewal well in advance 30 days of your expiry date, and if there is no communication on part of appropriate authority within a period of 90 days, then your registration is automatically renewed. It is deemed renewed. So there is a provision of deemed renewed in this PCPDT Act. But here I would like to mention one very interesting thing, because they have time of 90 days to respond. And say, for example, at the time of renewal, if you have applied 30 days prior, if I can give example, today is 9th of February, and your registration is expiring on 9th of February. If you have applied on 9th of January and today 30 days are already gone, and if there is no communication on part of appropriate authority, from next day only, from tomorrow only, your center is unregistered, because they have a period of 90 days to respond. So I always advise, at the time of renewal, apply 90 days prior. Though provision is to apply 30 days prior, but you apply for renewal 90 days prior. So even if appropriate authority doesn't respond within 90 days, then your center becomes automatically renewed. And as far as display is concerned, so certificate of registration is to be displayed at conspicuous place of your business. So here word conspicuous place is used. Sorry. So what is the conspicuous place? So literally it is meant that maximum visitor can have a look is a place that is considered as a conspicuous place. So sorry, waiting area or reception area is the place where maximum number of visitors will have a look to the certificate, because all the visitors who visits in reception area will not come into consulting room, and all the visitors comes in consulting room will not visit sonography room. So reception area is the area where you can have display of your certificate of registration. One more, this kind of board is to be displayed at conspicuous place. Name of hospital, address of hospital, and writing like this: antenatal sex determination is punishable offense, and sex determination is not done here. But this provision is different in different state. Say, for example, if I can give example of Gujarat, then there should be blue background, white font, and this type of writing should be there. In your state, it could be some different. So what is the provision in your state? Accordingly, you should display board like this at, again, conspicuous place. So in a waiting area, you can display this type of board. Bare Act, just I mentioned prior also, copy of Bare Act of PCPDT Act should be available to your hospital, to any visitor of your hospital on demand, and preferably it should be in English, but if it is in vernacular language, then it is also preferable, and it should be very recent one. If at all any amendment has come, then that amendment should be there in that very Bare Act copy of PCPDT Act. If you have old copy, and if you can attach amendment download from website or so, then also it will do. But copy of bare act of PCPDT Act should be with you, and it should be available on demand for perusal to the patient or relative or any visitor of hospital in your premises or hospital. One more important question was asked in past many times: which sonologist, who can do sonography? And this RTI was done, and State Family Welfare in Maharashtra state, this has happened. And after this, there was a meeting of Medical Council of India in 2011, and it was clarified that who is sonologist, and these are the members who were present in that meeting. So who should be called as a sonologist? Any OBGYN having postgraduate qualification in OBGYN as specified in Schedule of Indian Medical Council Act 1956, they are sonologists. Radiologists having postgraduate degree, diploma or DNB, they are sonologists. And as far as OBGYN concerned, DNB, postgraduate degree or diploma in OBGYN, they are also considered as a sonologist, and no separate training is required. But if person is simply MBBS, and if he or she has taken training for 6 months in OBGYN ultrasound training at government recognized teaching institution, then they are sonologists. Any teacher in radiology and OBGYN in department, respective department in medical college, they are sonologists. So it was clear in this meeting of Medical Council of India in 2011. And again, there was a meeting of Central Supervisory Board in 2012, because this question was asked by Honorable Supreme Court to Central Supervisory Board and the central government to clarify about this issue with sonologist. So in a meeting of Central Supervisory Board 2012, the consideration which was taken in meeting of Medical Council of India was taken into consideration, and they had decided that it was decided that medical practitioner with PG diploma degree or DNB in radiology or OBGYN would not be required to undergo 6 months training, and they are sonologists and they can do practice. But very important one more area is maintenance and preservation of record, because under this section 4 subsection 3, any deficiency or inaccuracy found in record shall amount to contravention of provision of section 5 or section 6 of Act, unless contrary is proved by person conducting antenatal sonography. So even mere inaccuracy or deficiency in record also will be considered as a contravention of section 5 and section 6 of this Act, and you may invite litigation merely on the ground of deficiency or inaccuracy of record. So which kind of record we are supposed to maintain? Register. This is register prescribed in Rule 9 Sub-Rule 1 with only 4 columns: serial number, name and address of patient who has undergone this prenatal diagnostic test, name of spouse or father, and date on which they first reported for such counseling and procedure or test. So with this 4 column, register is to be maintained under Rule 9 Sub-Rule 1. So no other detail is to be mentioned in this register. And this is very important thing. The record to be maintained by every genetic clinic in respect of each man or woman subjected to any prenatal diagnostic procedure, technique, test shall be as specified in Form F. So you will have to maintain this Form F when you are going to go for ultrasound examination in antenatal patient. But in other category, there are prescribed form. If you are running genetic counseling center, then you will have to fill Form D. If you are running genetic laboratory, then Form E. And genetic clinic, all ultrasonography center or imaging science center, then Form F. So these are prescribed form under PCPDT Act. There is Form G, and it is for invasive procedure. So if you are going to go for any invasive procedure, then you have to go for Form G. It should be duly signed by patient. Risk should be explained in language which patient can understand. You can send specimen to registered genetic laboratory only, and genetic laboratory can receive specimen or sample from registered center only, and it shall not be necessary for genetic laboratory to obtain a fresh consent if consent of patient is taken by genetic clinic. So at genetic clinic, if Form G is filled up and consent of patient is taken, then genetic laboratory need not to go for consent of patient again. So this is Form G. But word of caution, when you are going to go for invasive procedure, then in Form F also you will have to fill up the Form F also, and in that form there are 4 parts in Form F: A, B, C, and D. Part A is general information of patient. Part B is for non-invasive procedure. So if you are going to go for only sonography, then part B is to be filled up. Part D is declaration, and part C is invasive. So if you are going to go for invasive procedure, then you will have to go for part C in Form F. So whenever you are going to go for invasive procedure, all the parts A, B, C, and D you will have to fill up. And if you are going to go for only sonography, then part A, B, and D you will have to fill. As far as declaration is concerned, this is very important part. Declaration on part of pregnant woman, and it is mentioned that I, Miss or Mrs. so and so, declare that by undergoing ultrasonography, imaging science, etc., I do not want to know sex of my fetus, and signature or thumb impression of pregnant woman is very much mandatory. And if she is giving thumb impression, then thumb impression should be attested by person who knows that patient. Declaration on part of person who has done sonography. So I, Dr. So and so, declare that while conducting ultrasonography examination or imaging scanning on Mrs. So and so, I have neither detected nor disclosed the sex of her fetus to anybody in any manner, and signature of doctor. So on Form F and Form G, as per the case maybe, just we discussed prior, and on report of sonography and imaging science, if you have habit to give separate report of sonography to the patient, so at the end of your report, this kind of declaration should be there. So declaration in Form F and declaration at the end of your sonography report is very much required under Rule 10 Sub-Rule 1A under PCPDT Act. And this prescribed form should be filled in duplicate, and one is to be kept for office record, and one is to be sent to appropriate authority at the end of month within 5 days of next month. So it is very much mandatory to send record very much in time. And as far as maintenance and preservation of record is concerned, submission of Form F online is also required in few of the state. If in your state, if it is required to send it online, then you are supposed to send it online and or on physical ground also. Written consent of patient under Section 5, subsection 1B is very much mandatory. So whenever you are going to go for simple sonography or invasive procedure, consent of patient is very much required. Consent doesn't mean declaration. Declaration which is in Form F, it is simple declaration, because in that declaration patient gives that I do not want to know sex of my baby. It is not consent. So separate consent is to be taken from patient that I give my consent to go for sonography or invasive procedure. And if you are going to go for invasive procedure, then you have to go for Form G. And in that Form G, consent of patient is already there. So no separate consent is required. But merely on sonography, when you are going to go for form F, separate consent of patient is very much required. Patient give consent like this. I give my consent for sonography. It is explained to me. And if sonography report is very normal, I will not go for termination of pregnancy. That way patient will give consent in whenever you are going to go for mere sonography and when you are filling form F. Recommendation sheet or letter. Many times you are referred patient by another doctor, either registered medical practitioner, family physician, or any other gynecologist or any specialty. Many a times it is patient is referred by her relative also, and who could be non-medical person. So in this type of situation, recommendation sheet or recommendation letter, you are under obligation to attach with form F, and that form F is to be with you. You have not sent this letter or sheet to appropriate authority. It is with you as a office record. And it is very clearly mentioned in form F, referral slip to be preserved carefully with form F. This is column 7 of form F, and in that form F it is mentioned. But if it is a self-referral, say for example, patient has directly come to you, or you are gynecologist and you are going to go for sonography, it becomes a self-referral. So if it is a self-referral, then case paper of patient where you have advised sonography, you have to attach that case paper with form F, and separate referral slip you will have to prepare for which indication you have advised sonography. So it is very clear, because self-referral doesn't mean a client coming to a clinic and requesting for test, or the relative requesting for a test or test of a pregnant woman. So in this type of situation, when you are examining person and you are going to go for sonography, then separate self-referral will be considered, and case paper and the newly formed referral sheet will be prepared, and you will have to attach with form F. You can have a record on computer, on electric equipments or dictaphone, but printed copy of record shall be taken and preserved after authentication by a person responsible for such record. So if you have preserved all the records on computer, but printed copy you will have to take, and it should be signed by person who is authorized for the same. Intimation of change. Many a times there is a change in employee, change of place, change of address, or change of equipments. Then now you are under obligation to inform appropriate authority. Intimation, not permission. So you will have to intimate appropriate authority at least 30 days in advance of the expected date of such change. But many a times it is not possible. Say for example, one person is coming to your hospital as a visiting sonologist, and if he says, from tomorrow I am not going to come to your hospital, so it is not possible to inform appropriate authority in advance. But in this type of situation, in one of the cases, Supreme Court has given a verdict that if you can inform appropriate authority within 7 days of this kind of change, then it will be done. It is as good as you have informed well in advance. Who should intimate? Owner of the hospital or sonologist who is doing sonography? Because many a times in so many centers, owner is non-medical person and he has hired services of sonologist. So in this type of situation, owner should intimate appropriate authority of such change. But for a word of caution, I would advise that sonologist should also inform, because in one of the cases which happened in Gujarat, one sonologist was visiting, the gynecologist was visiting as a sonologist to a hospital who was a person of that hospital, owner of that hospital was allopathic person. He was BHMS, that is homeopathic graduate. And after some time, that sonologist left that services, and he intimated the owner that I am not going to come from tomorrow as a sonologist. But that BHMS doctor continued to do sonography with the name of that sonologist who had already left the services of that very owner. And one day there was one inspection on part of appropriate authority, and it was found, and case was filed against that sonologist also, because that very owner used to fill up the form on name of sonologist, and he was signing the document, form F, etc. So whenever you are visiting any hospital, and if you take decision not to give further services, then you should also intimate appropriate authority that from tomorrow I am not going to give my services as sonology to this very center. It is on your safer side. One more area, intimation of change. Center is registered as a sonography center. Now you want to change it as a genetic clinic. What will you do in this type of situation? So many a time appropriate authority may ask for fresh registration with full fees, or change with different of fees, or may change merely on application. So it becomes it depends upon the discretion or interpretation on part of appropriate authority, but you will have to intimate appropriate authority in a case of any change of employee or address or place. As such, there is registration of place under provision of this PCPDT Act. It is a registration of place and not the person of or machine, but place which is registered under PCPDT Act. You will have to give all the details, how many persons are working as a sonologist in this center, and how many machines, that is how many sonography machines are there, with all the details of machine and all the details of person. All the details of person means name, address, registration number of medical council should be there, and detail of all the machine with make, model, and number. So all this detail you have to give to the appropriate authority, but there is a registration of place only, and only details is to be provided. Still, many appropriate authority insist separate registration for each machine with registration fee, which is wrong interpretation on part of appropriate authority. Once place is registered, you can have n number of sonography machine in that very center, and n number of person can work as a sonologist in that very center. Only intimation you have to give. Detail of machine, just I mentioned, make, model, manufacturer, and whether this machine is immovable or portable, you have to mention. Sale of machine. Many times, sale of machine becomes a very important area as far as intimation to the appropriate authority is concerned, because it is very specifically mentioned in section 3B and rule 3A. One cannot buy, install, or use sonography machine for antenatal sonography unless center is registered and detail of machine is recorded for that very center. So it is very clear. Many times machine is to be sent for repair. So in this type of situation, intimate appropriate authority. If repair is possible at your place only, then nothing to worry. But if machine is to be shifted to workshop, then you should intimate appropriate authority with report of engineer that this machine is for repair and this machine should be shifted to for repair to workshop, and then only you should repair machine. If it is permanent non-use, many a time machine is not repairable one, and if you have only one machine, then in this type of situation, and one more area, if you are going to give buyback this machine to the company and purchasing new machine, then in this type of situation, if you have only one machine, then surrender certificate of registration to appropriate authority, because once you give this machine for buyback to the company, you have no machine at that point of time. So certificate is to be surrendered to appropriate authority. And if it is permanent non-use, and if you are going to purchase one more machine, so till you purchase new machine, you have to surrender a certificate to appropriate authority. Appropriate authority should be intimated about permanent non-use. You cannot give it buyback to company straight away without information to appropriate authority. Appropriate authority will demolish the machine. Many a time, few of the appropriate authority will not allow buyback to the company when it is total non-use machine, because there should not be misuse of that machine is the motto. So appropriate authority will demolish the machine. So in this type of situation, you will intimate appropriate authority that machine is in permanent non-use, and appropriate authority will visit your hospital, or he will delegate any other officer to visit your hospital, and in his or her presence, machine will be totally demolished and it should not be reused in any way. This is the motto of this part. Under Rule 3, it was amended under Rule 3. Each medical practitioner qualified under Act to conduct sonography in genetic clinic or ultrasound clinic or imaging center shall be permitted to be registered with maximum 2 such clinic or center within district. Here within district word is very important. You can visit 2 more center in nearby district, but in the same district you cannot visit more than 2 center. But this amendment was challenged in court of law. Almost in 5 different courts it was challenged, in Aurangabad, Bangalore, Chandigarh, Chhattisgarh, and in Delhi. So all High Court have stated this. So in all these 5 respective states, it is already stay, and one can visit more than 2 centers also. But when this type of litigations happened, I mean appeal happened, then Supreme Court, Delhi High Court wrote to Central Ministry that there is a appeal in this type of situation, and better you write to your respective state appropriate authority of all the state to implement this stay, that till final judgment comes, person is not banned not to go in a more than 2 center. So it is stay, and as on today, we can practice in more than 2 center also in the same district. So status quo is that instruction from center to all the state appropriate authority. One more area under section 30, appropriate authority or person designated by appropriate authority suo moto or on complaint may visit your center, and if they found any reason to believe, then they may have power of to seize your machine also, and cooperate them whenever they visit your hospital. They are not your enemy, and answer their question very patiently. And there are remedies also. If they have taken any actions against you, then there are some remedies also. So in which kind of this situation you will have to go for remedy. If notice is issued, machine is seized, registration is suspended, or registration is cancelled. So in this situation, you have a provision to go for appeal also. And if court case is filed against you, then also you can challenge in higher fora. If sonography machine is sealed, then what to do? So you can have a discussion with your professional colleague and have a medical opinion. You can have a phone call to advocate and have a legal opinion, and you can have a phone call to medical legal person and you can have a medical legal opinion how to approach in this type of situation. But very important thing, stay calm and try to avoid surprise, anger, panic and self-doubt. Do not ignore the thing. Be honest and do not try to hide any facts. reply on letter pad whenever you are served with a notice, and keep a copy of your reply for your office record. And whenever you are preferring appeal, then you should prefer appeal within 30 days. But if you have crossed the 30 days and if you can convince appropriate authority, then on satisfaction of sufficient cause of delay, appropriate authority may condone delay. And if you are agreed with the decision of sub-district appropriate authority, you can prefer appeal to district appropriate authority. If you are agreed with the district appropriate authority, then you can prefer appeal in state appropriate authority or union territory as per the case may be, or to state government, and same way to central appropriate authority, central government. But each appeal shall be disposed of within 60 days of receipt of that application. So appropriate authority where you have preferred appeal, they are under obligation to dispose of this case within 60 days of receipt of the case. There are judicial remedies also. You can prefer appeal in judicial magistrate first class or metropolitan magistrate as per the case may be. You can prefer appeal in sessions court, in high court, and in Supreme Court. So there are judicial remedies also. So it is very obvious. There are two ways of meeting difficulties. Either you alter the difficulties or you may alter yourself to meet them. And this gentleman has so many staircases, but he doesn't know how to use them. So it doesn't matter how many resources you have. If you do not know how to use them, they will never be enough. There are so many provisions in law in your favor, even in PCPDT Act also, and in other acts also. So have some basic legal knowledge and always obtain medical legal advice whenever you are in doubt or whenever you have suffered any action on part of appropriate authority. Because in spite of all these professional and occupational hazards, our journey to serve human and mankind is always on and on. So if you want to sleep like this, take tender care of your patient, comply with the provisions of PCPDT Act, pray your Almighty God before going to sleep, and keep my visiting card below your pillow. And to conclude, take medical legal advice from point one, because once you submit any record to anybody, appropriate authority or in court, then you cannot change that record. So before submitting this type of record, if you have time, then you should have a word with medical legal counselor before submitting any record. And to conclude my talk, this is law of leopard behind innocent gynecologist, and see the role of medical legal counselor, how he can be useful in any given situation. So please do not hesitate and have a phone call to medical legal advisor and be safe. So God bless you. Have a litigation-free medical practice. With regards, salute to all, and Haveri OBGYN Society and Dr. Surekha Madam in particular for inviting me to share my views. Thank you very much. Please do not assume. Please ask if any query, any questions, if time and Madam permits. Thank you very much.
So thank you so much, sir. It was a very nice talk, and with a pin drop silence. It was very detailed from minor to major, displaying an apron certificate, displaying a conspicuous area, and writing things on a blue background, and keeping the records properly. So it was very detailed and very eye-opening session, sir. Thank you so much.
One thing just I mentioned, but nameplate should be there. If you are wearing apron, or even you are not wearing apron also, nameplate should be displayed. It is also one requisite of PCPDT.
Yeah, sir. Should we need to wear a?
Because in few of the state, they have filed litigation against our Foxian friends merely on that. In Gangapur district of Rajasthan, at the same time, 18 gynecologists were given notice and their license were suspended. Okay. Of course, they went into appeal. I was counsel for them, and we won the case in higher fora. So merely on ground that they were not wearing apron with nameplate. So as per PCPDT Act, no necessity to wear apron, but nameplate should be there.
Okay. And any question? Triveni, can you read the questions? So there is one doubt, like
Yes.
if we are planning to go out for 1 or 2 months or sick leave or a maternity leave. So should we need to inform a PCPDT people?
So as per PCPDT Act, machine should not be used by person whose name is not given to appropriate authority. And you never know in your absence whether machine will be misused rather not used. So it is always better to seal that room where your machine is there. If you are going to go for any locum person to look after your patient in your absence, and if he or she is going to use that machine, that intimate appropriate authority 30 days prior that Dr. So and so is going to visit my hospital from this period to this period, and he will use my sonography machine. But at the same time, if at all he uses your sonography machine, then Form F, Form G, whichever the case may be, he will have to fill this form, and in time that form should be sent to appropriate authority. It is very much clear. One more area. In few of the state, there is a provision. In that very month, if you have no sonography, not a single sonography, then also you will have to intimate appropriate authority with a nil report. So if in your state, if there is provision and if you are out of station for more than 1 month, then at the end of 1 month, somebody should send a report that there was no sonography in this very center. So please consider our report of sonography nil. So not to end up into any problem. So this type of precaution you should take.
Thank you, sir.
Good evening. Thank you so much for the wonderful visuals also
Yes,
that made
yes.
the presentation so interesting.
Thank you, madam.
We have one question that the format for the consent, do we have a proper format, or it is just the consent form by the patient?
It is simple 3-4 lines.
Okay.
I undersign so and so, give my consent that everything was explained to me as far as sonography is concerned. And if everything is normal, I won't go for termination of pregnancy. Simple. It is a mere consent for sonography. If patient is for invasive procedure, then no separate consent is required, because in Form G, everything is mentioned. We had been explained about all the side and after effects of the procedure, and we have given consent after understanding the all the procedure. So in Form G, it is already there. So no separate consent is required, but merely on sonography, because many a times interpretation on part of appropriate authority is there. If you go with Form F in triplicate, I mean triplicate, one is to be given to the patient, one is to be kept for office record, and one is to be sent to the appropriate authority at the end of month. So that form given to that patient is considered as a consent, but few of the appropriate authority is not of the same opinion, because in declaration it is given that I do not want to know sex of my baby. It is not the consent. So few of the appropriate authority interprets that way, and merely on that ground they may give you a notice also. So not to end up into this kind of form, you can prepare this kind of consent form on your letterhead, and in every time you have to take consent, and you will go for 2 forms. One is to kept for office record, and one is to be given to the patient, because under section 5 of this PCPDT Act, one form is to be given to the patient.
Thank you, sir.
Any more questions, Triveni?
I'm not able to see the chat from this link,
Yeah.
madam.
But if
Sharon,
you allow
any
any,
question?
if you allow delegates to raise any question, we are here to solve the query. No issue.
Requesting 1 minute, madam. 1 minute, one video is there. We can
No,
present
no,
here.
wait,
Yes.
let them finish the questions and question.
Yes, if any delegate have any question, they may put their question in chat box, or if uh, uh, they may raise hand, and if you allow to speak, because I do not know which technique you have taken for this webinar.
Yeah.
A technical person can only say.
Yeah.
Can any delegate be allowed to raise question other than chat box also?
Sharon, they're asking you.
Madam, they can only chat, sir.
Okay, no issue. Then you can request all the delegates, whosoever have any question, they may put their question in chat box, and we are happy to answer.
Yes, sir. Inform, sir.
Ask that Neelam to do that.
Yes, madam. It's informed, madam.
So there is no question from the delegate side.
Okay, no issue.
Just 1 minute, one video is there, madam. Shall we present that video?
Okay.
If it's your permission.
Yeah.
Nagbhushan?
I will share.
Yeah, please.
Was this audible?
So this is video only, or audio is there?
Sir,
It's with
video,
audio.
sir, with video, sir.
Okay.
It's with video, audio and video both.
Okay.
Was it audible?
Because
Hello?
the voice is not there. Only video is displayed.
Nagbhushan voice ಬರ್ತಾ ಇಲ್ಲ. ನೀವು mute unmute ಮಾಡಿ.
Was that audible?
It is not audible.
Not audible.
1 second.
No, Nagbhushan. It is not audible. 1 second.
Yeah, could be some technical errors. Hello, could be some
Sir,
technical errors.
when you share your video, there is a one option, share with
Okay.
sound. You can just click the share with sound and then share.
Hello.
Yes.
Was it audible now? Hello.
It is
Hello.
not audible. Can any one
Okay,
of
okay.
you
You
just
can.
read and tell about entry and close?
Okay, madam. You can continue. You can continue. No issues.
Triveni, any questions are there?
Ma'am, I'm not able to see the delegates chat box.
Yeah. There, I don't know what. There are no questions.
Neelam sir.
Sharon,
Neelam sir,
if there are no questions, can we end the session? Sharon, you talk something about
Yes,
your product and close it.
yes, madam.
We'll be just
Thank you,
waiting.
doctor.
Sir is waiting that side.
Yes, madam. Thank you, doctor. Thank you for the valuable time. Thanks for the opportunity to giving this Zoom webinar. Thank you, Sir MC Patil sir, and thank you, Dr. Handral madam. Our product is mainly Dydrofem madam, Dydrogistan. Last time we have introduced already. And apart from Dydrofem, Oro for XT pause. Today specially requesting Dydrofem madam. Thank you for the opportunity.
Okay. So thank you, sir. Thank you, MC Patil sir, for sparing your precious time with us. So henceforth we'll be troubling you, and
yes,
we
at
want
any
some
time.
more sessions with
We
you.
are always there to assist our Foxian friends, no issue. At any time
Yes.
you can call.
Yes, sir. I'll come up with some other. I'll discuss with my society people and come up with different topics. And thanks for the cooperation. Thank you so much, sir.
Thank
Shall
you.
we close, sir?
Oh, yes.
Yes, madam.
Okay. Thank you, sir.
Thank you.
So should we end this meeting?
Oh, yes, you can.